Y'all doing all right? Well, like she said, my name is John Ross, and as a profession, I am a asset protection attorney. I protect people and their life savings from all kinds of things: the IRS, the devastating costs of long-term care, lawsuits, things like that. That's what I do professionally, but then personally, I have been president of the Tri-State Alzheimer's Alliance out of Texarkana for the last 10 years. I'm a board member for the Christus St. Michael Health System. And let's see, since I'm bragging on myself, what else? Hosted a radio show on Fox Talk for 10 years called Aging Insight, published a magazine called Aging Insight. I've been in Wall Street Journal, Forbes magazine, name it. Anyway, I know a few things about all this stuff. So that's enough about me. This is an interesting topic. I wrote a paper about 4 or 5 years ago for the University of Texas on this topic. I've since given this speech a bunch of different times. And I will say from the outset that if you have any issues with a frank discussion of sex, time to leave. There ain't no sense in beating around the bush about it, so we're going to be talking about it. And as I go forward, again, we'll have a little time at the end. If you have any questions, you can feel free to give me a shout. I mentioned being on the board at St. Michael's, and we were having a board meeting, and it was right before I was about to give the first speech on this, and somebody asked, they said, well, what is it that you're speaking about? And I said, well, it's sexual consent and Alzheimer's disease. And one of the gentlemen on the boards, he's probably in his 80s, and he said, "What's that got to do with anybody?" And I said, "Well, no, it's a serious deal." And I said, "Actually, if you look at the research, there was a study a while back, and they looked at people that were age 80 to 95 with a diagnosis of dementia. And over 2/3 of them reported having a healthy sexual lifestyle." So there you go. Of course, he looked at me and he says, "Who are these people?" But anyway, but here's actually where I got the idea for this topic, and it's the story of Henry Ray Hotz. So Henry here was he was a congressman, state congressman, I believe in Ohio. And he was a widower, and he's big in his church. And of course, he was an active member in the state Congress, so he's going to the state capitol all the time. But so like I said, he was big in his church, and he sang in the church, and there was a lady in the choir, and her name was Donna, and she was a widow also, and they were both about 80, give or take. I think maybe when they first met, late 70s or early 80s, but right around there. And they hit it off, singing in the choir together, and it wasn't too long until the two of them decided to tie the knot. Now, on an unrelated topic, I do a whole nother program on another paper that I wrote called The Top 10 Reasons to Live in Sin as an Older American. But that's not my topic for today. But anyway, so Donna and Henry, they hit it off, they get married. She's into beekeeping, and he learns how to help her with the beekeeping. And she would go to the state capitol and help him with his congressional duties. But it wasn't very long into their new marriage that she started having some mental decline, and it really hit her pretty hard. And within just a matter of a year or two, she had declined significantly. And she was wandering off at the state capitol because he would be busy, and just those sort of things. And Henry was kind of working with her kids. She had her own kids, obviously, that, late life marriages, you got the blended family. And they decided to move her into a assisted living, memory care type facility. And when she moved in, they did the MME, and for the medical people around, they'll know what that is. It's the mini mental exam. And I believe it's a score of 1 to 30. Anybody can correct me on that. I'm not a doctor. But on a scale of 1 to 30, she scored a 3. 1 being the worst. So obviously her Alzheimer's was pretty progressed at that point. And after they moved in, one of the, when you go into an assisted living, they'll have like a caregiver meeting, and they'll have the director of nursing or maybe the physician, social worker types, and they kind of come up with a care plan and they're having this care meeting, and Henry's there, and one of the daughters is there. And one of the questions that the daughter raised to the medical staff, she said, I've got a question. Does my mother have the mental capacity to consent to sex? And of course, the doctor kind of looked at it and was like, well, probably not. I did think that was kind of an odd question, but okay. But anyway, so fast forward, and Henry's showing up twice a day. He goes over for lunch, comes back in the evening, doing that every day of the week, seeing Donna. And one night, Donna was in a 2-person room, and it's got the partition between them, and the roommate in Donna's room reports that she has heard sexual noises coming from behind the barrier. That gets reported then to the nursing staff, which then makes its way to the daughter. The daughter calls the police, has her mother taken to the hospital, and has a rape kit performed. They did not find any evidence of sexual assault on her person, but they did find bodily fluids on the bed. That police officers, investigating officers, wrote up a report, passed that over to the district attorney. The district attorney took that in front of a grand jury and charged Mr. Rayhans with aggravated sexual assault, i.e. rape in the 2nd degree, minimum sentence 20 years in prison. Now, I will say from an attorney's standpoint, this was not a great case. You didn't have any evidence of sexual assault in the rape kit, although you did have the fluids. Your best witness is a lady who only heard, quote, sexual noises. But they took this thing all the way to a jury trial. At 84, I believe, is when they did the jury trial, and a 20-year prison sentence would have been a death sentence in prison for Mr. Rayhans. He had, of course, already resigned his seat in the Congress because of all of this. And in the end, the jury found him not guilty. But what we don't know is why the jury found him not guilty. Was it because they didn't think the sex happened? Or was it because they did think the sex happened, but they somehow didn't think that it rose to the level of a crime? Man, we don't know the answer to that, but we do know he was found not guilty. All right, so let's get into it a little bit. These slides are backwards. Anyway, so here's a couple of things. So if we go all the way back, y'all have heard of something like a directive to physicians, or also known as a living will, right? That's you putting in writing whether or not to keep you on the machines if they're only prolonging the moment of your death, right? You've probably all heard of such a critter. They haven't actually been around forever. They came around the 1960s. But you can go all the way back to this particular case in New York. There was a lady who had a life-ending disease. She's at the hospital, and she is refusing medical treatment, and the hospital says, we're ignoring you, and we're going to perform the medical treatment on you against your will. Because our job is to save lives, and we don't care if you want to die. And there was a lawsuit that went up to this, and you get this very famous quote here, but basically saying that each one of us as an American has the free right to decide what is done with our body. Period. End of story. Right? So we have this as a backdrop, right? So we know that we can do with our bodies whatever we want to do. And that'll kind of come into play later because then we also have to look at the criminal side of these sort of things. So this is the Arkansas statute on rape. And, it says kind of in part there, a person commits sexual assault in the second degree if the person engages in sexual contact with another person, and I've cut out the main parts that are important here, who is mentally defective or mentally incapacitated. Notice that there's no intent element there. There's no knowledge element there. If you have sex with a person who is mentally incompetent, you have committed rape in the second degree in the state of Arkansas. When I was doing this, I mentioned earlier that I was looking at it on the Texas side and initially, and Texas actually has two elements. You have to know about it. You have to know that they're incapacitated and do it. But there's a knowledge element. You have to know about it. Arkansas doesn't have a knowledge. It just says if the person is incapacitated. But I did look at several cases kind of leading up to this, and it does kind of demonstrate the points. But for example, there was one where this guy was a friend of a family. They lived next door to each other, and this young woman who was mentally incapacitated, she's an adult, but she's got a very, very low IQ. And the neighbor and her end up having sex. He's charged with rape based on her mental disability. And the court, when he appealed that case, the court came back and they said, yeah, no, you're guilty, man. You knew this family, you knew her situation, you knew she was mentally incapacitated. But then there was another case that I looked at, and this guy is driving down the road, and there's a woman standing on the side of the road, and she flags him down, and so he swings over and picks her up. And after a short drive later, they pull into a park and start having sex, as you do. Come to find out, the young woman had walked away from a group home, and then this guy picks her up, and of course then they have sex. Well, he's charged and ultimately convicted of having sex with a person who was mentally incompetent. But that case actually got overturned, and the reason it got overturned was because all of the testimony at the court was that this particular person could present, at least initially, as competent. Like if you just met her on the street, you wouldn't necessarily think anything was wrong with her. You would have to be around her for a significant period of time, certainly longer than a car ride to the park. And so he was actually ended up, that conviction was overturned and he was not guilty. So you think about this in the Alzheimer's context, right? I mean, if you're talking about whether or not the person is mentally incompetent, I mean, if you've experienced with Alzheimer's, does it make a difference if you have sex in the morning or the evening? I mean, right? Yeah, I mean, you're nodding your head because, yeah, I mean, you can have a person with Alzheimer's and have a perfectly competent conversation with them in the morning, and a totally incompetent person at 6 o'clock in the evening. And so, where's the knowledge and the time frame in all of this, right? And so it becomes a very odd situation when you start dealing with something like Alzheimer's. And then I read this one really strange case. So there's a couple, and they're both mentally incapacitated. And they're married. And the wife does not work. She's incapable of holding a job. The husband, he sweeps the floors at the McDonald's, right? But very menial type job. They not only are they married, they had a child together. But the child was taken from them by Child Protective Services as soon as it was born because neither of them had the mental capacity to rear a child. Now there's another guy, he lives next door to them. And, the husband goes off to work. And next thing you know, the neighbor and the wife, incapacitated, wife, they pick up a relationship while the husband's away at work, as you do. And then ultimately, when all of this comes out, he is arrested and he's charged with rape because she lacks the mental capacity to consent to sex. Except this is a weird deal, right? Because here we have a woman who is legally married and known to be engaging in sexual activity because she's had a child with her husband. We're not charging her husband with rape. We're going to charge the neighbor with rape. And that guy's conviction was actually upheld. He was still guilty, and the court came up with this bizarre reading, and I'm not going to read it to you, but basically, in short terms, they said, well, there's a difference between sex between a married couple and sex with your neighbor. Maybe there is, maybe there isn't. I don't know. Now, you can also see that that was 1990, and the difference between society's position on sex in 1990 and 2024 have got to be a little bit different based on everything I see on the news. So I don't know that you would get the same result anymore, but it does bring up it is kind of is there a difference between outsider versus a married couple? Well, in the context of rape, generally no. Prior to about 1979, you could not be convicted of raping your spouse. It was 1979, there was the first case where they convicted a guy of raping his own wife. Since then, it is now illegal to rape your wife in every state in the United States except South Carolina. I don't know why they never caught up with it, but that's the rule. So I've got a couple of little thought processes here. And based on everything we've talked about, and you can just think of it to yourself. But let's just say we have an Alzheimer's patient that they can't remember their spouse's name, right? They don't necessarily know who they are, but they're affectionate, and they refer to them as that nice man. Now, if this Alzheimer's patient is voluntarily having sex with her spouse, who she doesn't actually know is her spouse. Is that right? I don't know. What about, so I actually I think this is the one that I came up with. I had a client, and she was just telling me a funny story. She came in, and her husband has Alzheimer's, and for the last 2 years, they've had kind of the same routine. She gets him in bed, and then she makes sure he stays there, and then she goes and she brushes her teeth and brushes her hair and does all of her things, and then she gets in bed, gives him a good night kiss, they roll over, they go to sleep. Been doing that for the last year or two. A little cold in the bedroom. Except for this night. This particular night, she gets into bed, she gives him a good night kiss, and he kind of kisses back, a little harder. And arms get entangled and legs get entangled and things are heating up, and first time in a little while. And as things progress a little bit, all of a sudden the husband pulls back and he says, "You think my wife's going to find out about this?" And she looks back at him and says, "Nah, this be our little secret." Did she rape him? He consented, but he didn't think it was with her. I mean, it was her, but he thought it was somebody not his wife. I don't know. What about they have sex with their spouse, who they do recognize, but then what if they just can't remember it within moments after the fact? Does that change the deal? What if they have consensual sex with their spouse, who they recognize, but their demeanor is very childlike? You know, after the act and they're laying there in bed and the wife looks over and says, "Pinky promise nobody will find out about this." Actually, the reason that's in quotation marks is because that came straight from the case where the guy knew the neighbor and he had known the family. And they described the incapacitated woman that he had had sex with as having a very childlike demeanor, including the fact that after they had sex, she would say, "Pinky promise, nobody will find out." And he was convicted. You could call this one the, now I can't think, what's the Supreme Court justice's name? It's just slipped my brain. What'd you say? No, the former one, not Ginsburg. Anyway, her husband had Alzheimer's. And she used to actually take him to the Supreme Court, and he would wander around in the back halls. But that eventually got to be too much, and so she had to put him in a memory care facility. And she wrote in her book that when she would go to the memory care facility, he didn't have any idea who she was. And every day that he would show up, or she would show up, he would be excited that she was there. And first thing he wanted to do was introduce her to his girlfriend. And then they would all three go have lunch together. And I mean, she kind of laughed about it as, just kind of the nature of the beast. But, what if those two are having sex? There's a nursing home, and I won't tell you where it is or which one it is. But they have the boom boom room. Sandra Day O'Connor. Yes, thank you. There's a nursing home I know of that has the boom boom room. That way, if couples want to have sex, they have a special place for them. This is probably the hardest one. So they have the Alzheimer's patient. They're completely nonverbal. They show no signs of recognition toward family. They'll smile. They'll hold hands with people that they're comfortable around, including the spouse. During the sexual contact, the patient makes little sound, lies prone, but they smile. Based on most psychological research, one of the very last things you lose is your desire for physical contact. And so you can have forgotten how to speak, you can have forgotten how to walk, you can have forgotten who all of your loved ones are, and yet you probably still desire touch, possibly even sexual touch. Don't know. We can't ask them. But that's the hardest one because it seems like they're enjoying themselves. All right. A lot of times, moving on. So a lot of times if you're talking about incapacitated people, a lot of times you end up having to get a guardianship. There's a whole line of cases out there related to marriage in guardianships. Now, the most common of those cases are where you have somebody who has Alzheimer's, they're at home, they have a caregiver who is defrauding them, stealing their money. I actually have a whole nother presentation, and the title of it is the Abuser's Playbook, because it seems like every one of these exploiters follows, it's like there's a manual, because they all follow it just almost to a T. It's like step 1, step 2, step 3, step 4. But a lot of times the family comes in at some point and they've recognized that there's something going on here. Maybe checks are bouncing or whatever the deal is. And of course, dad or whoever it is, they think they're fine. They dang sure don't want their stupid kids telling them what to do. And so the kids are wrong, the caregiver's right. And so the kids are going to go, we're going to go and have dad declared incompetent by a court and become his legal guardian. And at the same time, dad and the caregiver run down and get married. And so you'll see a number of, there's a whole line of cases related to whether or not you can invalidate a marriage like that. But there's actually even a few cases out there on whether or not a guardian could consent to marriage on behalf of an incapacitated person. You'll see this a lot of times. Maybe somebody has an adult disabled child. Maybe they have Downs or some other issue, and they're moderately functional, and they can engage in society and maybe even hold a part-time job, kind of like the guy we talked about earlier. And they find somebody, maybe another incapacitated person, and they're in love and they want to get married, but their parents were appointed as their legal guardian when they turned 18. And so they have no right to contract, which means they can't get married. And so the question becomes, could the guardian then go to the court and petition the court for approval to allow the ward to be married? And the courts have almost universally said yes. That's within the court's breadth of powers, is to consent to that sort of thing. And if we go back to that other case, one of the things in that long thing that I read out, it said that sex is a vital part of marriage. And so if you're consenting, if you're the guardian and you're consenting to the person to get married, are you not also consenting to them having sex even though they're incapacitated? If sex is a fundamental part of marriage and you can consent to marriage, right? I mean, that would seem to be the logical conclusion from that. Of course, then that brings up all kinds of weird things, right? Because, I mean, if I become incapacitated, who's the most likely person to become my guardian? My wife, right? I mean, if I'm incapacitated and I need a guardian, my wife is probably going to be the guardian. So then does my wife as my guardian, is she able to consent to me having sex with herself? In the legal world, we would call that self-dealing. Right? I mean, as the guardian, I can't sell the ward's house to myself for $1. Right? That's fraud. That's, that's self-dealing. That's me benefiting from my power as the guardian. And so if my wife is the guardian, can she consent to it? Again, I don't know. One thing I will say is, in a guardianship context, when you're doing a guardianship, legally speaking, guardianships are supposed to be as narrowly tailored as possible to meet the needs of the ward. And so essentially the powers that are taken away from the ward that are in the court order, they no longer have. But the powers that are not taken away from them, they would retain. And I gave this speech to a room full of 500 lawyers, and I asked the entire room, I said, has anybody in this room, and every one of them are guardianship attorneys, that's their primary practice. And I said, have any of y'all ever listed sex in your guardianship order? And of course the answer was absolutely no, not a single person in there. So it's not something common, but you can make a pretty good argument that if you didn't specifically remove their power to engage in sexual activity, that it was retained by the court, because the law says all the powers that are on the order, they don't have, and then any powers that are left off, they retain. Just kind of a strange situation. Which this brought me up to my next question as I was thinking about all of these different things. So going all the way back, I mean, we have, I talked about the living will, right? And the case that going all the way back to the 30s that says I have the power to decide what is done with my body. From that case and then on through the law, we get all of your things like a financial power of attorney, right? I can appoint somebody to handle business for me, pay my bills, sell my house, do all of those sort of things. I can appoint somebody as my agent on a medical power of attorney. If I appoint somebody as the agent on my medical power of attorney and I become incapacitated, then they can either consent to or withhold medical treatment for me. They decide, right? Because I can't decide, so they decide. And I mean, think about what that medical treatment could be. I mean, an amputation? So I can pre-consent, I can give somebody the power to consent to amputation of a limb, invasive surgery, withholding life-sustaining medical treatment. That agent under that power of attorney could say, you know what, no, John wouldn't want that. Let him die. And that's well established. I mean, we know that. In fact, I tell everybody I ever talk to, 4 things everybody ought to have if they're walking around and they're over the age of 18. You ought to have a durable power of attorney for business, a medical power of attorney for health decisions, a HIPAA authorization so that your family can get copies of your medical records, and a living will. Those 4 things. That's what my kids get for their 18th birthday. They love me. They think that's the best gift ever. They really don't. But the first time you do a guardianship for a 19-year-old who got in a car wreck and has a catastrophic head injury, and the parents can't talk to Blue Cross Blue Shield about their own child because it's a HIPAA violation, you dang sure make sure your kids have powers of attorney in place, right? And so when I say everybody over the age of 18 should have all of those things, I'm not joking. But it begs the question, well, could I then pre-consent to sexual activity? Could I do a power of attorney for sexual activity? I can decide what I can do with my body. We already know that in a medical context, I can give somebody the power to make all kinds of even life-ending decisions. So certainly I could do a power of attorney for sex. And I thought, I've never thought of that. I've certainly never heard of one. What would one look like? And of course, you're immediately going to run into a problem. What are you consenting to? Sex is a big word. Have you ever seen what's called statutory durable power of attorney? Yeah, so a durable power of attorney, that's the one for business. That's the one that would be for paying bills and that sort of stuff. The word statutory means it comes from the law. And so the Arkansas legislators get together and they pass a law. And if you were to go into the Arkansas Fiduciaries Code and go to a certain section, you would actually see a form. Like in the law is a form power of attorney. And it has I blank hereby appoint blank to perform the following acts. Initial in front of each. And then it has real estate powers, banking powers, blah, blah, blah. And it's got a whole laundry list there. And you can initial next to each one of them, or you can go all the way down to the bottom and just initial all of the above, right? And I thought, well, let's just start there. I'll give you a second to digest that.
Next slide.
But I thought, you would have to decide, right? What is it? What are you consenting to? And so you could initial next to the ones you were consenting to. Of course, then this begs the question, who am I appointing? Because again, typically if you're talking about like a husband and wife and you're doing medical power of attorney, who is your first agent? It's your spouse. And then you appoint maybe one of the kids as the second agent. Well, if I appoint my spouse, now she's consenting to sex with herself, which seems awkward. Well, yeah, dang sure not bringing the kids in as alternatives. What, I get my buddy and he just sits in the corner? That doesn't sound right either. And so I don't know how this would actually work, but it was kind of a fun thought process. So I'll tell you a quick story on that. I do a podcast called Big Picture Retirement, and I get 10,000 downloads a week on that from people all over the United States that listen to my podcast. And a couple of years ago, I gave this whole little presentation as a podcast episode and talked about the story of Henry Ray Hans, and I talked about my advance directive for sexual consent and whether or not it would be valid or not. And about it was maybe a couple of weeks after that episode premiered, I got an email from a guy in Seattle. And he said, John, I listened to your Big Picture Retirement podcast, really like it. Listen to the show on the sexual consent and the power of attorney for sexual consent, and that really intrigued me. He said, my wife and I, we have very strong religious beliefs, and based on those very strong religious beliefs, my body belongs to her, her body belongs to me. And so we were talking about it, and we think this is a really neat idea. And I was wondering if you could send me a copy of your sexual consent for power of attorney, because I have already made an appointment with my estate planning lawyer to discuss this. And I thought, oh my God, I would love to have a little camera in that room. Because you know that lawyer sitting in his big fancy office just thinking these folks are going to come in because they need to update the address for their son, or maybe they're going to make a specific bequest to their grandkids, or some other just normal, everyday, boring thing, and they whip out that and say, can you do one of these based on, Washington state law? I never heard back from them, so I don't know how it went. Here's one thing I will say, though, is I don't think it will work. Legally, although it was a fun thought experiment, legally, I don't think it would work. And the reason is if we go all the way back to the criminal statute. The criminal statute is very clear. If you have sex with a person who cannot consent because of mental incapacity, it's rape. Period. End of story. It doesn't say anything about, well, unless, they pre-consented or something like that, or, and I mean, at least, and certainly we expect the law to have the concept that you could consent at one phase and decide not to consent at another time in the future, right? And so I don't think having that advance directive in and of itself would shield you from a criminal prosecution under those circumstances, although it might be enough evidence to sway a jury if it were ever to come in. So, but I wouldn't rely on it just for that. So, I went a little fast through my presentation. Anybody have any questions about this at this stage?
Don't be afraid.
To protect your spouse, should you put something in a living trust in case she got dementia or you got dementia? So she didn't get involved in a marriage that she didn't consent to?
Yeah, so your question is, could you put something in place, like, for example, in advance where, if your spouse got Alzheimer's or dementia or something, that they then could not get married? Right. That's basically your question. Yeah. So the short answer is probably not. And the reason being, again, the power to engage in marriage is contractual, right? So it would almost be like asking, is there a way for me to, if I die, can I prevent my wife from writing a check or buying a car or buying a house? Those are contracts, right? Well, marriage is legally speaking, a contract. And so, unfortunately, there's no way to necessarily prevent the marriage from happening. Now, that being said, one thing that I have seen work many, many times, if, for example, let's say, is it Janice there in the front? All right, so me and Janice are married, right? And she and I, we're both concerned that if something happens to one of us, that the other one is going to do something stupid, right? Janice is like, John, I love you, but I know that if I die, you're going to marry a stripper named Cinnamon. And I don't want her getting half our stuff. I want it to go to the kids. And I say, yeah, you know what? That's actually a pretty legitimate concern. So, and so we might agree, for example, to set up our estate so that at the death of the first spouse, the assets are held, say, in a trust that maybe either I don't have full access to or maybe I don't have full control over. Now, if I have full access to it and full control over, I can do whatever shenanigans I want. But maybe we say, well, if I need to take large distributions, I have to get the kids involved, or something like that, right? Where there's some sort of check and balance on it. And if that would do a number of things. Like one, if I got married, well, the spouse isn't marrying that trust, in which case, even if that marriage ended in divorce, it wouldn't be divisible. So I've shielded it from that standpoint. From the predator spouse, the predator type spouse. And my wife does a pretty interesting program on predator spouses. After she had it was a year-long case involving the guardianship of a man who had had a stroke. We represented the children against his wife. We were trying to get the guardianship, and she was trying to keep us from getting the guardianship. This is the wife that he had been married to for about 2 years, and he had married her shortly after she had been paroled from Huntsville State Penitentiary after doing 4 years confinement for financial exploitation of old men, and he was her 16th husband. She's dead now, luckily. And I danced a jig when I found out. She was an evil, evil woman. But his stupid butt married her. He knew he was pen paling her in jail. So, I mean, he was a victim, but he was not an incompetent victim. He was a dumb one. And so, in any case, had his assets been tied in a way that she could not have gotten them, she would have passed him over as a potential victim and moved on to somebody that did have assets that she could get to. So a lot of times if you take the assets out of reach, you take away the predator spouse's motivation. And so then even if, like in this case, he would still be free to marry that crazy woman, but we wouldn't have been arguing about the assets and all of that because they would have been tied up in a trust or something. So anyway, that was a long answer to your relatively short question, but there you go.
My wife's got dementia.
Okay, hold on. They can't hear you, so hold on.
Okay. My wife's got dementia, severe. So in order to protect my kids from me doing something stupid, I should put that in a living trust.
You might consider putting that in some sort of trust, yes. Now saying the word... Right. Saying the word trust is like saying the word surgery. And so there's lots of different types out there. And it's the words on the paper that matter. But yes, if you're concerned that you might do something stupid, yes, you might want to take some actions while you are competent enough to make that type of decision. Likewise, when you have a spouse who's incapacitated like that, you also have to consider what happens if you die first and make sure she's protected as well. And so there's several elements that might need to be addressed in a situation like that. I often talk about, and because the statistics bear it out pretty good, a person with Alzheimer's disease from the time they're diagnosed has a 10 to 15 year life expectancy. Life expectancy of the spouse of somebody with Alzheimer's is about 3 years. So we have a tendency to focus on the needs of the sick spouse, and we fail to focus on the health toll that is taking on being that spousal caregiver. And so, you have to simultaneously look at both of those things, because from a purely medical standpoint, with her having a degenerative disease, you'll probably outlive her. But if the stress of being that spousal caregiver kills you first, we really need to make sure she's protected. So it's kind of a both sides sort of deal.
Is it too late?
And her question is it too late? And the answer is probably not. It just depends on how big of a hurdle you have to get there. For example, if we have powers of attorney in place for her, then a lot of the things could probably be done on her behalf via the power of attorney. If not, you may have to get a court involved and do the guardianship and get court approval for whatever you want to do. But it's almost never too late. It just depends on how big of a hurdle you have to get through to accomplish what you're going for. Yes, ma'am.
Okay. Follow up on that situation. Could a child come in after the fact and say, well, Dad, you had power of attorney for Mom, and you went and did this and made whatever changes, and I know Mom wanted the grandkids or whoever to have, and you manipulated or abused your power of attorney authority?
Yeah, so essentially what your question is can you use a power of attorney to do something that maybe the incapacitated person would not have wanted, right? Like in your description, right? Chuck's wife wants everything to go to the 3 kids, but he really doesn't like that Timmy kid anyway. And so he now wants to change his own planning and use the power of attorney to make sure that regardless of which one of them have died, that in the end, only the 2 kids get the stuff and not her, or not little Timmy, right? Maybe, and the answer is maybe, because it's going to come back to the words. Powers of attorney, again, powers of attorney are not all the same. As a general rule, you would not, a person can't use a power of attorney to benefit themselves. And they're supposed to make sure that what they're doing also benefits, it benefits the person, right? That's their whole job. It's what we call a fiduciary duty, right? The problem with the fiduciary duty, though, is especially in the long-term care context, you can actually run into a problem, right? So, and again, I give long answers to short questions, but for example, I appoint Janice as my power of attorney, right? And so we can now all agree that Janice's job is to use my assets for my benefit. I get in a car wreck this afternoon. I have a catastrophic brain injury. I'm going to have to go to long-term care, and that's going to be a permanent placement. It's going to cost at the rate of $9,000 a month, give or take. And I don't have long-term care insurance, and so it's either private pay until I'm broke or qualify me for Medicaid benefits. And so Janice goes and sees an attorney like me and says, hey, what can I do for John? And they say, well, hey, did you know that, we've talked about all of this, and John's got 4 kids, but his youngest one is on disability benefits. Did you know that you could transfer John's assets to a disabled child and qualify him for Medicaid in the process? And that's permitted within the rules. And you say, well, no. Janice says, I didn't know that. But I know that's the way John would probably, if the choice is between spending it all at the nursing home and spending it all, giving it to his youngest daughter, well, yeah, give it to his youngest daughter. And so she uses the power of attorney to do that, which would in fact qualify me for Medicaid in the process and preserve all of those assets, except for the fact that did she use them for me? No. She gave them all away. And so that would be a breach of her fiduciary duty. If I'm over the age of 55, that would be financial exploitation of the elderly. But on the other hand, if you asked me today and you said, hey, John, if you ever became incapacitated, would you want Janice to be able to make a gift on your behalf, even a disproportionate gift, if that made protecting your assets for Medicaid or some other government benefit? And I would probably say yes. In which case, when I drafted that power of attorney, it would not only say that I give Janice the power to pay my bills and do all the things for me, but also, in addition to that, what we call hot powers. And so, for example, the powers to make a gift, the powers to change a beneficiary designation, the powers to amend or revoke a trust, like what Chuck was talking about. And so, that's where I say it comes back to the power of attorney. Does Chuck's power of attorney give him the power to make those sort of decisions? I don't know. I'd have to look at it. If it doesn't, he could screw it up and the kids could come back. If it does, he's probably safe. So, long answer to simple questions. That's what I'm here for. Yes, ma'am.
So you mentioned 4 powers of attorney: durable, medical, you said HIPAA, and what was the 4th one?
Yeah, so
I had durable, medical, HIPAA.
Yeah, so the four things, the durable power of attorney, medical power of attorney, HIPAA authorization, and living will. Those 4 things everybody should be walking around. And if you are talking about doing it for an 18-year-old, then the other thing you're going to want is a FERPA release. Yeah, everybody looks at me like, what? What? FERPA. That's the Federal Educational Privacy Rights Act. That's why you can't call the college and find out if your kid's going to class or not. And so if you would like to know whether or not they are majoring in sorority parties, you need a FERPA release.
All right. My younger brother, 67, Alzheimer's, just diagnosed, so all this is new for me anyway. My husband and I are guardians now. We've had that done. My question is about any sexual activity that he may get into. And, right now, he's, right under our feet all the time. So, we would know about something and nothing's going on. But I know that he does know where porn is on his phone. And anyway, I'm just wondering about, my liabilities to that if he did get involved. And at the same time, it would be nice if he did meet somebody, that, not being, not having.
Right. Yeah. I mean, that's the thing, right? I mean, just because.
Nice person.
Right. Just because your brother or brother-in-law, just because your brother has Alzheimer's doesn't mean you don't want him to be happy and he can find love and all of those sort of things. And that's all wonderful. Your question is basically, is there a situation where you might have some sort of liability depending on his actions? Generally, no. So you're generally not responsible for them unless you are knowingly permitting something to happen, right? So this would be like, for example, if I let you borrow my car and you get into a car wreck, right? Well, that happens, and my insurance is going to pay for it, and it's not too big a deal. If you're on your 4th DWI and you try to blow into the monitor that's hooked into your own car and it won't start, and so I say, here, take my keys and drive mine, that's a different deal, right? And if you kill somebody in that car wreck, I'm going to jail too, right? Because that brings it to a whole nother level, right? So you would have to have some knowledge that was going on and that you're effectuating it, permitting it, or certainly not taking the attempts to prevent it, right? But it's got to be something that you kind of have some awareness of.
Well, and what if I do? But they're a well-thinking adult.
And that also brings a whole nother element into it, because where are they in the process? What do they have the capacity to understand and do versus not do? There was a real big dust-up in Texarkana this last year. There's a group home of mentally challenged young men, and the group home was carrying a group of them to the porn store and letting them watch porn movies in the little theater in the back. But they were kind of making their point was, look, these are grown men, they have sexual desires and sexual urges, and we're just, they understand what they're doing, and we're helping facilitate that, which is certainly appropriate for them, and it's not hurting anybody and all of that. Now, they got quite a bit of backlash, as you might imagine, off of that, but nothing certainly to the level of any sort of liability or criminal or anything like that, right? So yeah, if you want to take your brother to the Hustler Club in Shreveport, I think that's probably fine. I'm not suggesting you do that, but but I don't think that would get you into any trouble, I guess, is my extreme point there, right? On the other hand, like when we gave this presentation in Little Rock, one of the people in the audience, I don't know if it was their father or somebody, but he's sexually acting out, and like they were at a restaurant and he slapped the rear end of some 14-year-old girl that's walking by. That's a problem. And while I think an isolated incident like that is probably not something that would rise to the level of a criminal issue, On the other hand, if they then took him from there to Chuck E. Cheese and put him around a whole bunch of kids, that would be another problem, right? And so, yeah, I mean, I think that's where you have to kind of balance that. It's like, okay, if I have somebody who is sexually active, and hypersexuality in Alzheimer's is a very common sort of thing. As the disease affects the frontal lobe, you lose your ability to do things that things that you would have ordinarily been able to kind of tamp down. You can't tamp them down anymore. This is why you get the little preacher's wife that cusses like a sailor. She's always wanted to talk to you like that. She's just been able to keep it to herself. But she's lost that ability. And so you get a lot of that in the sexual context as well, right? People have these sexual urges, sexual thoughts. You see somebody walk by and you're like, wow, she looks good in those jeans. I'm not going to reach out and smack her though, right? Until I lose that ability. And if I've lost that ability and my guardian knows it, then they probably need to not put me in those positions. Stephanie's like, get him off the podium before he says anything crazier.
He is from Texas.
I grew up in Texas. Our main office is in Texarkana, but I actually live half the week here in Hot Springs. And so I also office here as well. Yes, ma'am. That'll be the last question because I think it's time.
Okay, back to the power of attorney. If you have one already in place and it's not really appropriate, you need to make changes, can you make another with additional?
Yeah, so if I have made a power of attorney and it needs to be changed or amended, can I? Absolutely. Yes, and powers of attorney, I mean, all estate planning documents should probably be looked at every so often. For example, I mean, I've been doing this for 20 years. 20 years ago, when I was drafting a power of attorney for somebody, I didn't put anything in there about retrieving a password. But I do now. Right? I've got a whole section in there about social media accounts and password retrieval and that sort of thing, right? Because times change. Not that law changed, it's just that if I know that if somebody is trying to close out a Google account for their loved one who's incapacitated, Google's gonna want something in writing that specifically says they have the power to deal with Google. Yeah, so your question is, you got to listen. My experience with powers of attorney in particular, and not that you would necessarily have to list them specifically, but they do want something, and I'll give you a couple of quick examples, right? A statement that says, I appoint you to handle my banking transactions, right? I've had banks say, that does not include the power to close the account because that's not a banking transaction. That doesn't include the power to access the safety deposit box at that bank because it's not a banking transaction. Right? So that doesn't need to say banking transactions. It needs to say banking transactions, which includes opening and closing accounts, making withdrawals, making deposits, accessing safety deposit box, closing the account, opening new accounts, setting up the online bill pay service, retrieving the password to the online account, right? And that's just banking. Now expand that out to the rest of the things that you can do as a free American over the age of 18, right? And unfortunately, the only way, again, mine just keep getting longer because I keep adding to it because somebody has a problem and then I fix that problem in theirs and everybody after that, right? And so then you just keep going over and it keeps getting worse and worse, but there you go. Yes. All right. Well, listen, I appreciate y'all letting me run my mouth. Y'all have a good day.